Hello, welcome to Legalese. Legalese is a presentation of the Northern Middlesex Bar Association. It's designed to bring topics of legal interest to the community. My name is Christopher Lilly. I'm your host today. I am joined by Attorney Joseph Presti from Littleton.
Hi, Chris. How are you?
Hi, Joe. How are you doing?
Good.
Good. Joe had joined us previously with Attorney Hyde.
Yes.
And had spoken on the topic that we're going to speak on today. The topic today is special education needs. We felt it was a good topic to bring to your attention at this stage where, this being September, during the time of our filming, beginning of the school year, where sometimes parents may find that there are certain needs that their child may have that fit into the category of special education.
Yes.
Or learning disabilities, something that needs to be addressed. And what should they do with a situation that they found themselves presented with, and how should they get the ball rolling as far as the special education law? So, Joe, I'm going to ask you that question. I as a parent of I found out that my son or daughter has a learning disability or appears to have a learning disability. What are my options with respect to the school system?
Fair enough. If your child is 3 years old or under, that would fall under the purview of early intervention.
Okay.
That can be accessed through your pediatrician's office.
All right.
Once a child is 3 years old, that falls under the purview of your school district.
Okay.
So you would have to call your school district, explain what concerns you may have, whether it's a motor function or a learning function or whatever the problem may be perceived as, and ask for an evaluation in that particular area.
Now, should I begin that with a call or should I begin that in writing?
As an attorney, I like everything in writing.
Sure.
To establish some sort of trail. So yes, you could make an initial call, but always follow up with a letter or an email to the special education director.
Now, once you've made that request, is there a certain timetable that gets triggered?
There is. I probably shouldn't say this, but I don't get too worried about timetables because in the whole scheme of things, a couple of days one way or another is not going to impact an evaluation dramatically. You have to understand schools are under tremendous pressure when it comes to special education. Okay. And if they need a few extra days, more than willing to grant them that.
Tremendous pressure from whom?
From laws, from the federal government, from the state government, and what they have to provide. Teachers wouldn't want to be one today because of the paperwork nightmare that they have to go through as far as filling out evaluations and writing IEPs and so on for the children in special ed and that are covered by special ed nowadays.
Okay, so I've begun the process with my son or daughter, and I've made the call. I followed up with a letter. What happens next? Once
the evaluation is completed, the special education department, the school, will call an IEP meeting. Okay. IEP is an independent education plan that will be put into place. What they'll do is they'll assemble a team of school experts in the particular area that was of concern. And as parents, you are also a member of that team. Okay. You will review the evaluation. A determination will be made as to whether or not your child qualifies for special education.
Who performs the evaluation?
You have the option of providing your own evaluation, and the school has to provide an evaluation. The difference is
who performs that?
Whatever specialist. Let's say the problem happens to be in the area of speech. Okay. The district's speech evaluator, speech pathologist usually, will perform the evaluation. Okay. I am a fan of coming in with your own private evaluation as well, because private evaluations, although they may cost you some money if insurance does not cover it, they tend to be a little bit more thorough than a school evaluation. Again, schools are limited by the amount of time and funds that they have. So you can come in with your own private evaluation, compare it to the school's evaluation. The only caveat is schools are not required by law to accept the results of a private evaluation. They merely have to consider the results.
Okay.
But if the results are so dramatically different between the private and the public, the school-funded evaluation, then there could potentially be an issue there.
Okay. Well, let's get back to the meeting now. This is our first meeting where we sit down. It's who's present? You got the parents. The
Parents are
teachers?
part of the team. Usually the special education coordinator. Sometimes it depends on the district. Sometimes the special ed director will go. Sometimes they have special ed coordinators for each particular school or grade level. The expert in the particular area of concern, whether it be speech or physical therapy or psychological, whatever it happens to be. It could be all of them. It depends on what the concerns are, as well as maybe a principal or professional such as that will attend.
And what's on the table at that point as far as what's to be discussed at that meeting?
What's on the table is to discuss the evaluations, both public and private, what the parents' concerns are, and then there is a step-by-step process that the state has and the federal government have developed to determine eligibility.
Okay.
If a child, after going through those steps, is determined they meet eligibility for special ed, then a plan has to be put into place in the form of an IEP
All right.
to determine what services that child may need. And it could be as simple as 30 minutes of speech a week, or it could be a much more intensive program of services.
Okay.
And then if that's acceptable to the parents, they simply sign off on that IEP plan, not right there and then because it takes time to develop, but they'll eventually sign off on it. If they don't agree with the IEP, they can reject the plan in whole or in part,
Okay.
and then go from there.
The rejection. Okay. Well, let's talk about that in just a second. At what point might an attorney get involved or an advocate?
Well, you have to determine, first of all, if an advocate or an attorney is necessary. The difference being, obviously, an attorney is a trained legal professional. An advocate, there's no state requirement or license to be called an advocate. It usually is someone who's had experience in the special education process through their own child, or they have a special affinity towards special education, and they will represent parents or children. They're obviously less costly than an attorney, but they do lack the legal knowledge to pursue a case and to understand the legal thresholds that have to be surmounted in order to prevail in a case, should a case go to a hearing or something like that.
So in what situation might I decide as a parent to bring in an advocate rather than an attorney?
Sure.
Or vice versa?
Sure. In relatively simple cases, an advocate is perfectly viable. In other words, if it's a one minor area, we'll use speech again. If a child's having a speech delay and it's simply a matter of getting the child some speech services and it's an initial couple of meetings, no problem with an advocate. An advocate can handle that. If it gets to the point where the public and the private evaluations are so dramatically apart from each other and the school is dead set that they are not going to give services of any type, then it might be time to call in an attorney.
Okay. Under what situation might the school say, we're not going to provide those services?
You'd have to get into the mind of a school department to determine that, unfortunately. I don't have the answer to that. By law, they cannot say we don't have the funding for that. That's illegal. But their experts, their testing may not show the type of significant delay that a private evaluation may.
So is it a question of eligibility at that point?
No, because a child could be eligible, but a parent may say that, well, I want Johnny to have this much in the way of services, and a school may say, well, we feel this is perfectly appropriate.
Okay.
And sometimes I have to go in and tell a parent, I think you are being a little bit unreasonable here. I think what's being provided or proposed is adequate. Sometimes the school department will feel that Johnny may outgrow their speech delay, and it will not affect their access to the curriculum. And that's the bar that has to be jumped over, if you will, to determine eligibility, if the disability will affect access to the curriculum.
So that meeting, that planning meeting, IEP plan meeting, would you be present for that?
If I'm retained by the parents, I will go to that meeting, yes.
Okay.
And I have not seen a school district yet that once they're notified that parents are bringing an attorney, they will also bring their attorney.
Is there a requirement to notify them then that they're bringing in an attorney?
I tell the parents that there's no legal requirement, but I always tell the parents to notify the school district just as a matter of courtesy.
You feel there's an advantage to doing that?
To notifying the school district? No, because what will happen in my experience is once an attorney shows up and they don't have their attorney, they'll call off the meeting.
I see.
So
there is an advantage to letting them know.
Yeah, in time, savings
Sure.
of time, sure.
Sure.
So yes, school districts always want their attorneys present.
And how would you become involved or interact with that school's attorney?
Well, again, the professionals, the education professionals will handle the meeting. Again, same procedure as before. Parents will express their concerns. They'll go over the reports. The attorneys are there to make sure that nothing is said that shouldn't be said, nothing's promised that shouldn't or couldn't be promised, and so on. Or if there is a particular point of contention between the schools and the parents, then the attorneys will get involved and start a discussion.
Okay.
Yeah.
Okay. So now let's deal with the situation where where the parents disagree with the findings, whether it be eligibility, whether it be how these needs are going to be addressed. What do you do at that point? What are the parents' options, with or without an attorney?
Well, the law that has to be followed is called administrative law. You don't immediately go to court. Okay. It's administrative law through the Bureau of Special Education Appeals. Right. And the process for remedying a disagreement, number one is if the parents in the school district cannot remedy it themselves, then you can ask for a mediation through the Bureau of Special Education Appeals.
Okay.
That's a free, no-cost solution. A meeting will be set up between parents and school department, and attorneys can attend. They may not attend. It's a very informal process where both parties will speak their mind. They'll be separated. The mediator will go back and forth and try to come to a resolution, and then a legally binding agreement as to the resolution will be signed.
Okay.
If that does not work, and sometimes I just advise clients don't even bother with mediation because we're so far apart, it's not going to work. Then you file for a hearing request at the Bureau of Special Education Appeals.
So how does the mediation kick in? Does it kick in because you filed for the hearing?
You have no. You have to file for a mediation. You have to physically notify the BSEA that you would like to have a mediation. Now, mediation has to be acceptable to both parties.
All right.
If the parents want a mediation and the school department says no mediation takes place.
Sure.
Versus a hearing, either party they don't have a choice. They have to participate.
Okay.
Yeah.
So I've gone through the meeting where the school has made a determination against my wishes or against what I feel is appropriate. What do I do to perfect my appeal? Or what do I do to
if you want to go
forward?
to a Bureau of Special Education hearing, then you could go pro se, which means represent yourself, not recommended.
Okay.
You could also hire an advocate to do that for you.
All right.
Again, not recommended. The statistics show of the hearings that happen on a yearly basis, the parents who are represented by attorneys are successful at a much higher rate than pro se or advocate represented parents.
Really?
Yes.
Okay.
Overall, the state does an incredible job of limiting the number of hearings on a yearly basis. Right. And that is a unique process that's been established by the state of Massachusetts and the Bureau of Special Ed Appeals in particular. So once an attorney, let's use that example because that's what we are, we file for a hearing request, date is established by the Bureau. As we get closer, all the discovery and interrogatories have been done. Usually a week or two before, the Director of Special Ed will call and ask if both parties are interested in what they call a pre-settlement conference,
Okay.
which again is a very informal meeting. She's, in this case, the director's a woman. She will read both cases. Everybody will sit in one room. You'll have up to an hour to explain your case. You could bring one witness if you'd like. And then she will separate both parties and have very frank discussions with both parties as to the strengths and weaknesses of their cases.
Kind of like a mediation.
Yes, but it's a lot more formal because now you're dealing with the head of special education appeals,
Gotcha.
whose opinion comes with a lot more authority. Although she cannot influence the hearing officers at all, but she's a very, very experienced individual.
Okay.
So her word means quite a bit.
Okay.
So she will give her frank opinion as to how strong or weak your case is, and almost every case I've participated in has settled at that point. Even if a school district all along has said, I'm not interested in settling, not interested in out-of-district placement, at that point, then it's settled. The downside is, if you go to a hearing, either party could potentially risk attorney's fees if they
Okay.
lose.
Is that right?
Yes.
So you could have, you as the parent may have to pay the attorney's fee of
The school district. And again, I've never seen that happen, but that legally could happen.
Is there a standard that has to be established before they would do that?
Yes.
Such as bad faith?
No,
or-
you have to substantially prevail. So let's say we are in a pre-settlement conference. If a school district proposes A, B, and C as a settlement offer, and you say, no, I want A, B, C, and D, and then you go to a hearing, and the hearing officer gives you A, B, and C, you cannot get attorney's fees, because if you only get what was proposed previously, that's not substantially prevailing.
Okay.
Okay? On the other hand, if you get less than, say, 50% of what you were asking for, that's not substantially prevailing. You have to prevail on a majority of your points in order to get attorney's fees.
So how often does this happen with the attorney's fees? I mean, that's
It happens.
unfortunately a real deterrent, I would think. to
It
people.
can be. It can be. Obviously, you're not going to file for a hearing only because you can get attorney's fees out of it. That's just, an extra bit if you happen to win. That's great. And sometimes you have to go to court to get those attorney's fees on top of that. So there's more attorney's fees involved too.
You have to sue in order to
Sometimes, yeah.
collect on the administrative award.
Yes. Yes.
Interesting.
Yeah.
Okay. Let me take a step back. You
Sure.
had mentioned something about discovery, the discovery process prior to the hearing. What would that entail? What would you, as an attorney for a parent, be looking for by way of discovery?
Well,
from the
sometimes
school
I
district?
may want to see the IEPs of the other students in the class. Redacted, of course, for personal information, but I might want to see the IEPs to determine if that child is in a classroom of peers.
Okay.
Or I may want to see resumes of the teachers who are giving that child services. Things such as that, because you want to make sure that people are qualified. You want to make sure that your child, if his only issue is speech, he's not in with kids who are autistic, who are socially at a different level than your child may be.
Okay.
If it's an integrated classroom, there's nothing you can do about that. But if it's a substantially separate classroom, which means your child gets pulled out for services, then there is something that can be done about that.
Okay. What are some of the services we're talking about? I'm proceeding as if we have a dispute throughout the process. Let's
Sure.
assume we don't have a dispute. What are some of the services that can be provided?
Typically, the services are speech, physical therapy, sensory integration therapy, occupational therapy, psychological therapy. Then a lot of times kids will have executive functioning diagnosis, which really means their memory is not working properly, whether it's working memory, what have you. And that may come under several different areas. There's also children who are on the spectrum who have PDD-NOS diagnosis, which means there's something wrong, but we're really not sure what's causing it at this point.
Okay.
So you have to take that over time to determine exactly what that child will react to, what may set that child off, and then work with that child and the child's parents and outside evaluators to try to formulate a plan.
Okay. How about an in-school plan in terms of what happens in the classroom if that's if there's going to be certain accommodations or?
Absolutely. Some children may need an FM system to magnify the sound in the classroom for them, or may need something as simple as seating towards the front of the classroom so they can see the board better, or an electronic device like an iPad.
Okay.
So there's no shortage of assistance that can be given to a child so that they can access the curriculum.
If my child's having trouble in the test-taking areas, that's brought on by.
It depends on why, but yes, extra time can be given. They might have someone who can take notes for your child as they get into the higher grades. If the child needs services that are severe enough, then they will pull the child and put them in a substantially separate classroom for a small period of time or an entire day. It all depends on what the services needed are. And then go into the mainstream classroom for particular subjects.
Okay.
The goal is to have that child in the mainstream classroom as much as possible.
Okay.
You know, the child may just need supervision at recess and lunch for socialization. It could be a myriad of things.
Okay. Yeah. All right. Now, so let's get back to the situation where we're talking about a hearing has occurred. If I'm dissatisfied with that hearing, any recourse?
You could always take it to court, but as you know, to appeal a particular judgment, there has to be something to appeal. Very rarely does it ever go to court. I could probably count on my hand the number of cases I've seen go to court in the last 10 years in Massachusetts for particular issues. And again, parents also have to consider money too. It's expensive.
Sure.
Not only to take a case to hearing, but then to take a case to court.
And in taking it to court, what are the issues at that point? Do
It
you
could
get
be
to relitigate it?
Yeah,
or?
it could be the same issue, but you know, you might want to try to determine, did the hearing officer issue a judgment in error? You know, was there something that happened, an evaluation that should not have been considered? Things like that.
Does the court rehear it, or do they accept what the hearing officer has said as a prima facie basis, and you have to try to, as a parent, overcome that? How does that work?
Yeah, you know, it happens so rarely. It really depends on the particular person, the judge hearing the case. But yeah, if you want to try to focus on the issue that you feel was ruled on incorrectly, and you know, try to prove your case in that respect.
Okay.
Yeah.
Okay. And you mentioned that there may come a time when, with a favorable decision from the hearing, that you may have to bring that into court to enforce it. What's the scenario under which that might
to enforce the awarding of attorney's fees.
Okay.
Yeah.
Just that.
Yes,
Just that
yes.
issue.
The hearing officer does not have the authority to award monetary damages, even though in IDEA, which is the federal law that special ed operates under, does give the party who substantially prevails attorney's fees. You still have to apply for those and go to court. The hearing officer only rules on the education issues at that point.
Okay, so it's still, I'm sorry, it's still open then, as far as the attorney's fees
As far as the
issue?
attorney's fees, yes. Yeah.
Okay.
Yeah.
Does the hearing officer make a recommendation about the?
It depends on the hearing officer.
Yeah.
Yeah.
Okay.
Yeah.
Okay. Well, if people need to get hold of you on their issues of special education, how would they do so? You have a website.
Yeah, the website is baystatespecialeducationadvocacy.com, all one word. And what we offer is a variety of advocacy as well as legal services.
Okay.
We also have a team of professionals in various fields, again, speech, OT, SI, executive functioning, that can give evaluations that you would work with privately to determine if your child's needs are severe enough to pursue special education services.
Okay.
And we also have articles on there that I've written for newspapers in the past. And
So it's a good website to come and educate yourself
yeah, there's
on.
always room for improvement, but
Yeah.
Yes. Yep.
Okay.
So,
Well-
but it's a very interesting field. But I would caution parents that if you are looking for an attorney, it's like any type of law. I'm an attorney. I could practice medical malpractice, but I'm not qualified to.
Right.
Same thing with special education law. It's a specialty unto itself.
Sure.
So you want to find an attorney
Somebody who
has
practices
done
in
it
the
before.
area.
Yeah,
Sure, sure.
absolutely.
Well, I thank you for joining us here today. I think you've given quite a bit of knowledge and understanding that you bring to the table here, and I thank you for that. And I would encourage people that if you decide that you do have special education needs, that you do seek out local counsel and determine that what can be done to address those needs. There is the option through the school, but I would suggest certainly beginning with local counsel and finding out what the lay of the land is. Nothing said here should be relied upon by you as far as answering any particularized questions, but I would suggest that you talk to a local counsel. As I said, my name is Attorney Christopher Lilly. On behalf of myself and Attorney Joseph Presti, I thank you for watching.